Hello everybody, this is Irene Weisman, immigration attorney. Today is Monday, April 28th, 2025. I hope everybody is doing well. I will try to run through some news, some changes, some information, hopefully useful information for at least some of you, okay? So I'm sure you've seen this in the news. A lot of students who are here, foreign exchange students here on student visas, many have received SEVIS terminations, indicating that they are no longer in status for no apparent reason whatsoever. Unfortunately, when somebody receives a SEVIS termination letter, the school can't issue a new I-20. So when we try to do, when a student falls out of status and we try to restore them back into the student status, one of the first things that I need is a new I-20 from a school, but the school won't be able to issue the new I-20 if SEVIS record is terminated. So the good news is, in the past week, many students have received the notice that their SEVIS records were terminated. Received another notice indicating that their SEVIS records were in fact restored. Okay, so that's some good positive news. If it impacted you, just check back with your school, check back with your DSO, designated student official, check back with your attorney if you need to reinstate your student visa, or if you are okay to continue and everything is okay there. So not everybody whose SEVIS record was terminated received the restoration letter, but many students did. So just, if it impacts you, be on the lookout for that. Obviously check your email. This is what I tell, I do this, it's my basically my practice. I check my spam folder every day, every evening, sometimes more than every evening, because unfortunately I find that periodically very important emails go to spam. So check your spam folders, people, okay? Because sometimes mail just goes to spam, okay? Friday evening, this past Friday that just passed, pretty late at night, received notification, new memo from from immigration courts regarding changes of venue. Okay, so what is a change of venue? Your immigration court case, your removal case, is scheduled in the court where the court thinks where you reside, in the jurisdiction where the court thinks you reside. So if you if you ended up being in immigration court because you came in through a port of entry in the last couple of years or before, and so whatever address you provided, that's going to be the address that they have. If you ended up in immigration court because the USCIS asylum office sent your file there, whatever address they had on file, that's where it's going to be in that jurisdiction. Or if you had a USCIS interview, something didn't go right and they placed you in removal proceedings. That is happening a lot lately. I spoke about that. All benefit cases, if they get denied and you become removable, that litigation unit within USCIS is very busy right now, reviewing files and scheduling people to come to court, issuing those notices to appear, and they will issue it to the address that USCIS had on file. So once again, very important to maintain the correct address with USCIS. That's number one. And number two, check your mail, check your email, just in case. But I started talking about the changes of venue. So let's say you're in removal proceedings and you have a court hearing. You live in New York, your scheduled court date is in Miami because either you used to live in the Miami-Dade area, or when you came in through the border, that's where you used to live and that's the address you provided, but you no longer reside there. So you need a change of venue because your case is going to be heard in the jurisdiction where you physically reside. Occasionally, the court would keep a case for a respondent who has moved, but they don't like to do that, okay? Occasionally it happens, for one reason or another, but once again, they don't typically like to do that. So, with people, it's just not convenient, for anybody. So what needs to be done is change of venue. Sometimes the court does it on its own, and sometimes your lawyers, we would do it, for you, because you're no longer in Miami, you're now in New York, and your case needs to be heard here. So the new memo came out for changes of venue, basically, questioning judges against granting changes of venue indiscriminately. They're saying that the judges will now have to review the file, make sure that pleadings are done, and that there is no relief is submitted, and everything is basically all set for the new court to just schedule a date for the hearing. And if there's any outstanding issues of fact or law that remain, that needs to be adjudicated by the initial court who now has the case. So this memo, it doesn't necessarily discourage the change of venue, or it doesn't necessarily stop it. However, it certainly places a heavier burden on you. A lot of things have now need to be done before this change of venue can take place. And even if these things are done, it's not a guarantee that the judge in, say, Miami is going to change this venue to the court in New York prior to having the master court hearing, okay? And if that master is in person, that would place the undue burden on you and on your attorney if there is no WebEx, okay? If WebEx is allowed, great, but if WebEx is not allowed, that's unfortunate. I have a few cases where I have submitted my motions of change of venue. One is actually, in fact, in Miami, and all relief has been submitted, written pleadings have been submitted. I did my part, everything is submitted. They're just asking for the court to change the venue. We'll see what happens. I don't know. That particular motion for a change of venue, I submitted a couple of days before the court issued that memo. So we'll see what happens. And I have a couple of more pending. It remains to be seen what the court is going to do and whether they will make us attend that master just to go through everything before they change, even though all documents are there and they have it. I don't know. We'll see. I'll keep you guys posted onto that. And there was another memo. I can't remember if I had the chance to talk about this or not, but this memo is on administrative closures of cases. So what is administrative closure? Okay, people don't know, because there is a termination of your case in court, and then there is administrative closure. Administrative closure means you are still in removal proceedings, okay? Nobody has taken you out of it. You're just not on the active docket. Your case is closed as far as the docket is concerned, and you do not have any future hearing date, and they're not going to schedule one unless they put your case back on the active calendar. And either party can put the case back on the active calendar. It can be you, or it can be DHS, or it can be the court, okay? Usually it's not the court. Usually it's either you or DHS that would put the case back on, on the active calendar after it has been administratively closed. Now, this memo came out, and they can't necessarily. So the power of the immigration judge to administratively close a case right now, as it stands right now, it's in the ICPM, Immigration Court Practice Manual. So, and it's codified, so they can't just overturn it. They need to, overturn some regs in order to do that, and which is more difficult to do. But they're really starting to limit this power of the immigration judges to do that. And this tool of administrative closure, it's very useful and very handy in a variety of types of cases. For example, when something is pending in USCIS, but you have removal proceedings that are happening simultaneously, and certain cases are adjudicated by USCIS. For example, I-130s, which is the immigrant visa petition on behalf of either a spouse or a family member, or the special immigrant juvenile, those petitions, the I-360s, the VAVAs, the U visas, the T visas. Okay, so all of those benefits are adjudicated by USCIS, and while that's happening, the immigration court typically would place the removal case on hold and let USCIS adjudicate that case. So that power of the court to use administrative closure is being limited now, or so it seems. Or, they're trying to do that. So again, I'm not sure how that's going to play out, because this is all fairly recent. It actually happened before, about 7-8 years ago, and it was rough, especially on those cases that had those benefits applications pending with USCIS. And in my practice of the types of cases that I handle, it's going to impact the spousal cases where we have I-130 pending, and we need to apply for the 601A, the stateside waiver, because for you to apply for the stateside waiver, the case in court has to be either terminated or administratively closed. Okay, so we'll see how that's going to play out, because now that whole, I'm actually probably maybe later in the week or next week we'll do a whole segment on this. I know I did this before when I started the YouTube thing, but I think we need to go back to it because things have changed. Because what's happening now is that they're issuing notices to appear for these types of I-130s that need the 601A waivers. And now with the administrative closure being limited, we'll have to think twice whether we want to submit that type of a case or not. So I'll go back to this topic separately, and just do it on its own to talk about, the types of situations, the procedure, and whether it's going to make sense to do it now or not, which, I assume is going to be an individualized situation anyways, but this is in fact happening. Okay, so procedures that are happening by memorandums that are issued internally, that are impacting the way things are done in immigration court and at USCIS. So it's not necessarily the law that is changing, it is the procedure of how things are done that is changing in both USCIS and the immigration court, and that is impacting the cases that are pending and the future cases that we may bring before those bodies. So we'll see how that goes. And I will talk to you soon, everybody. I'll try to keep everybody posted. Have a great day, and I'll talk to you soon. Bye.